start the Administrative Regulation Review Subcommittee for the month of August. Secretary, will you please call the roll?
Senator Rocky Adams. Senator Wilson. Senator Yates.
Present.
Representative Bridges.
Here.
Representative Gordon.
Yes.
Representative Marzian. Co-Chair West. And Chair Lewis.
Here, with the quorum being present, the subcommittee is duly constituted to do business. The first matter of business is approval of the minutes from the last meeting. Are there any additions or corrections to the minutes? Is there a motion for approval? Is there a second? Without objection, so ordered. Please call the first regulation.
Board of Pharmacy, 201 KAR 2045 and 2165. Both regulations have staff suggested amendments.
201 KR 2045 amends provisions to specify tasks that registered pharmacy technicians may perform under different types of supervision, specify tasks that certified pharmacy technicians are prohibited from performing, establish pharmacy technician registration application requirements, and incorporate by reference the pharmacy technician registration and renewal applications. 201 KR 2165 amends provisions to clarify that a pharmacist may delegate the transferring of a prescription of a previously dispensed non-controlled substance to a certified pharmacy technician. The staff suggested amendments make technical corrections to the administrative regulations and incorporated forms to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please identify yourselves for the record?
Yes, good afternoon. Chris Harlow, Executive Director.
Jessica Brown, General Counsel.
Thank you all for coming today. There are staff amendments. Is there a motion for approval of the staff amendments? Without objections, so ordered. Are there any questions from members of the subcommittee? Seeing none, thank you for coming. Please call the next regulation.
Board of Cosmetology, 201 KAR 12010, 030, 060, 082, 100, 190, 260, 280, and 290. All regulations have staff suggested amendments.
201 KAR 12010 amends provisions to require the Board of Cosmetology Executive Director to perform duties assigned by the Board, clarify that the Executive Director may take specific actions only with the Board's approval, and remove the Executive Director's authority to investigate a reported violation. 201 KR 12030 amends provisions to establish a license expiration date, allow proof of continuous practice to be one of the criteria for reciprocal licensure, allow reciprocal licensing from U.S. territories, include military reciprocal licensure, establish a minimum 1-month time frame for examination retakes, establish additional requirements for licensed schools, and make substantial changes to material incorporated by reference. The Board states that many of these amendments are intended to implement statutory amendments established in Senate Bill 22 of the 2025 regular session of the General Assembly. 201 KR 12060 amends provisions to remove a cosmetology board member's authority to investigate a licensee and reduce the number of license establishment inspections from twice to once every license term.
201 KAR 12082 amends to update coursework requirements, increase training hours from 8 hours to 9 hours per day, change the minimum faculty to student ratio from 1 instructor per 20 students to 1 instructor per 25 students, exclude apprentice instructors from the ratio calculation, require an instructor to submit evidence to the Board of specialized training and education that demonstrates the instructor can safely instruct students regarding dermaplaning techniques, and update material incorporated by reference. 201 KAR 12100 amends to update the definitions of disinfectant and sterilize to include the use of germicidal ultraviolet energy, require a written medical authorization before returning to work after diagnosis of a communicable disease, and prohibit the use of a straight razor without a guard. 201 KAR 12190 amends to authorize the Board to appoint at least 2 board members to the complaint committee, specify that board staff and council may assist the committee but cannot vote, prohibit anonymous complaints, increase the time to respond to the complaint from 10 days to 30 calendar days, add the option for the committee to refer the matter to the full board for consideration and require referral if the committee cannot agree, and update material incorporated by reference.
201 KAR 12260 is being amended to reflect that licensure fee. 12280 is being amended to update the requirements for dermaplaning, and 12290 is being amended to change the length of time a permit is valid and add a provision that allows the board to prescribe conditions it deems necessary to ensure the safety, health, or welfare of the general public. The staff amendments to this package of regulations amend various sections to comply with the drafting and formatting requirements of KRS Chapter 13A and make technical.
Would you please identify yourselves for the record?
Eden Davis Stevens, General Counsel for the Board of Cosmetology.
Joni Upchurch, Executive Director at the Board of Cosmetology.
Thank you all for coming. There are staff amendments. Is there a motion for approval of staff amendments? Is there a second? Without objections, so ordered. Are there any questions from members of the subcommittee? Senator Yates.
Thank you, Mr. Chair. And as you saw my face, I popped up a couple. They said that they would exclude the ability to use straight razors.
That's actually always been excluded from the Board of Cosmetology that is licensed by the Board of Barbering. Cosmetologists are not allowed to use a straight razor.
But the Board of Barbery is?
Yes.
Okay, I was going to say I have a couple of
Yeah.
barbers going to be upset. All right, thank you.
Representative Marcian.
Thank you, Mr. Chair. Is there any concern about an instructor increasing the number of students from 20 to 25? Will that give less time for the students to learn or be difficult for the instructor?
We have received comments for both in favor of increasing to 25 and some concern in increasing it. Of course, the program does not have to go all the way up to 25 if they just determine that it's a better ratio to be less than 25. But this allows for programs that have the capability to cover different students. They have students that are part-time and once they come in through, so it helps with their ratio to not to have an additional instructor on hand just for somebody that might be overlapping for an hour. So it's a fairly, most programs are fairly flexible, so somebody might be coming from 8 to 1 and then another person might be coming in from 12 to 5 to gain their hours for their respective program. Mm-hmm.
Back to Senator Yates.
Thank you. And I know we've been working on some different regulations and changes to help people get back to work, and I really appreciate that. Is there a need right now to extend the class sizes? Is there a wait to get in? I know we're working right now to make sure that we get people, especially second chance and other ways. We've increased with the mobile barbering so people can kind of show up and find people where they are, whether they're in facilities and rehabilitation homes, things like that. Is there a need to expand these classes right now, or is there a wait list?
So we have 53 schools total across the state. Many of those do have a wait list for their program, especially the schools that are like KCTCS, Campbellsville, are schools that only enroll during the beginning of the semester. So those tend to have a little more of a wait list. But as in, this would just allow, some people thought it was quality versus quantity. I get that as well, but this does allow our private schools the ability to offer those part-time hours
Thank you.
without having to add an additional cost of an instructor. Yeah.
Any other members have any questions? Thank you for your answers. Please call the next regulation.
Board of Licensure for Occupational Therapy, 201 KAR 28240 Emergency. And this regulation has staff suggested amendments.
201 KR 28240E amends the Occupational Therapy Compact to add 4 new compact rules adopted on April 16, 2025 that include the rules on the new compact rules include the FBI criminal background check rule, member state implementation rule, occupational therapy compact fee rule, and the national exam definition rule. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourselves for the record?
Hi, everyone. I'm Lily Coiner.
Check your mic. Make sure that green light's on.
I'll use this one. Hi, I'm Lily Coiner, Board Counsel for the Kentucky Board of Licensure for Occupational Therapy.
I'm Jill Phelps. I'm the chair of the Kentucky Board of Licensure for OT.
Thank you all for coming today. There is a staff amendment. Is there a motion for approval? Without objection, so ordered. Do any members have any questions? My co-chair, Senator West.
Thank you, Mr. Chair. getting into the weeds a little bit, getting into a little technical question here. In this past session, we passed House Bill 6, and it kind of sets up a little bit different framework for how regulations flow through the process. And I was made aware that this particular regulation does not have the governor's certification or the general certification. I don't think it has either. Can you comment on that or mention that, or are you aware of that, or could you talk about that?
So are you referring to the statement of emergency?
No, I'm talking about these. It's called a statement of certification.
Okay, so our agency was instructed to file the way it was filed.
Gotcha. Okay. So what you're telling me is you don't know, which is it's fine actually, because that part of that is in court currently, and I don't know if there's a stay on that or not. But you answered my question. That's all I need to know.
Okay.
Thank you. Feel free to comment if you have additional comment on that. Okay. Thank you.
Any other members have any additional questions? Thank you all for coming. Please call the next regulation.
Department for Fish and Wildlife Resources, 301 KAR 1017, 2031, 2221, 3001, 3010, 4120, and 6006. Regulations 301, 3001, 3010, and 4120 have staff suggested amendments.
301 KAR 1017 repeals 301 KAR 1015. 301 KAR 2031 repeals 301 KAR 2030 because updated provisions are being moved to 301 KAR 3150. 301 KAR 2221 amends to change the bag limit for northern pintails from 1 pintail daily to 3 pintails daily.
301 KAR 3001 establishes definitions for 301 KAR Chapter 3. 3010 is being amended to create special use wildlife management areas that restrict certain public use due to the size of the property, its location, or because of deed restrictions at the time of purchase. Allow for the use of trail cameras on WMAs if the trail cameras are properly identified. Conform with Hunter Orange requirements and require groups with a valid WMA user permit that holds events at a shooting range to provide the department with a sign-in sheet from those events within 30 days. 4120 establishes a comprehensive list of reportable wildlife, livestock, poultry, and fish diseases and the conditions under which the diseases shall be reported and which individuals are authorized to euthanize wildlife suspected of having a reportable disease. 301 KAR 6006 repeals 301 KAR 6005 relating to boat registration fees because those requirements will be included in amendments to 301 KAR 5022. The staff amendments to these regulations amend various sections to add statutory citations, correct statutory and regulatory citations, add definitions, comply with the drafting and formatting requirements of KRS Chapter 13A, and make technical changes.
Would you please identify yourself for the record?
Stephen Fields, Department Counsel.
Thank you for coming today. There are staff amendments. Is there a motion for approval? Without objection, so ordered. Do any members have any questions? I know we have discussed a possible deferral. I do have a question first, though, dealing with the wildlife disease reporting regulation. Can you just kind of give me a brief overview of what that looks like and any changes being made?
This is a new administrative regulation, so it obviously it's all changes, but basically just people that are in the wildlife industry, either as vets or testing and so forth, if they discover reportable diseases, our veterinarian would like them to report those to us so that we would be able to deal with any potential concerns with disease spread and so forth.
Sure. Makes sense. And as to the possible agency deferral, you're looking at 301 KAR 2031 is the agency requesting a deferral?
Yes, we would like to request a deferral on that one just to get our timing right on the replacement reg so that we don't have a gap.
Sure. Is there a motion? Is there a second? Without objections, so ordered. The regulation is deferred. Thank you for coming.
Thank you all.
Please call the next regulation.
Economic Development Finance Authority, 307 KAR 1070 Emergency.
307 KAR 1070 Emergency establishes the application, criteria, fee structure, and economic analysis to evaluate applications for the Kentucky Entertainment Incentive Program.
Would you please identify yourselves for the record?
I'm Matt Wingate. I'm the General Counsel for the Cabinet.
And I'm Chad Zemlick. I'm the Deputy General Counsel.
Thank you all for coming. There are no amendments to this regulation. I know there was some confusion at the beginning of the committee meeting. If you could just explain,
Sure.
I guess, the 307 KR 1070 versus the one coming next month on the both emergency regulations and what that looks like.
And we're happy to do that. And thanks for reaching out and giving us a little heads up on that. So what precipitated the filing of this emergency reg that's before us today, the 070, is kind of a multitude of things. One being we have the Cabinet was transferred this program in 2022, and during the lifetime of the program had not been oversubscribed with interest. But when you gain national interest, you're going to have better quality projects and such. So we ran up against a situation where it looked like this program was going to exceed its allocation of credits without having a reg on place to differentiate the higher quality projects from the lesser quality ones. Simultaneously with encountering that, we had Senate Bill 1 from this last regular session that was filed that created a office of film, or a film office, and a film council to administer the program going forward. That that bill did not have an emergency provision in it, would take effect July 1. Simultaneously, in House Bill 622, you had a situation where $25 million of the reserve funding for the continuous film projects wasn't, in statute prior to that point, wasn't accessible to the remaining projects until July 1. So in order to provide continuity under the program so you don't have projects that are delayed and not being able to receive funds under the program, we filed an emergency reg that articulated some basis by looking at what the General Assembly had articulated in Senate Bill 1 as some areas to be considering under these projects to evaluate the purposes and the intent under the program. So this reg was simply put in place to allow the ability of KEDFA to administer the program during the interim between the program shifting to the newly formed Film Council in July. With that, we also were under a situation where the entirety of the corpus of the funds, and it's a good thing, like I said, when you have a program that's successful, we're oversubscribed for that 1 month. So that's what provoked the need for us to file this. This one relates solely to KEDFA's administration of the program, which the program is now transferred to the council, and they'll be the entity that, and you'll see the statutory, while they mimic each other slightly, there's going to be some differences in each of these because the statutes were different at the time that were in effect. But with that being said, and I understand the concerns about having two regs that have very similar naming mechanisms, but with the bases for the incentive agreements that we enter into were essentially founded in the contents of this reg, and for us to voluntarily withdraw it, I don't want to have any concerns of affirmative, waivers of any type of provisions therein. But does that help explain?
It does, and thank you for the clarification on that. And if you're willing also to clarify the 080 next month, we'll have staff work with you on that. Do any members have any questions, comments? Thank you all for coming.
Yep.
Please call the next regulation.
Department of Workplace Standards, 803 KAR 2404 Emergency. 803-2404 emergency amends federal requirements for personal protective equipment in the construction industry to ensure that the equipment is safe for the work being done and properly fitted.
Would you please identify yourselves for the record?
Robin Maples, OSH Standards Specialist for the Department of Workplace Standards.
Jason Hernandez, General Counsel for the Department of Workplace Standards Legal Division.
Good afternoon, Chuck Stribling, Deputy Commissioner, Department of Workplace Standards.
Thank you all for coming today. There are no amendments. Any members have any questions? Co-Chair West.
Thank you, Mr. Chairman. My question relates to a similar question I had earlier for the occupational therapy folks. Technical question. Under HB 6, we got some new requirements pertaining to certification. I don't think this reg has that certification on it. Can you go into that a little bit, explain that? There's an initial certification, then there's a governor certification requirement. Is that
just similar to the other answer, sir? It was agency advice.
Agency advice.
Yes.
Could you?
That's all I know.
Could you go give me a little bit more detail on when you say agency advice? Someone higher up in the agency told you that this is the work product we're giving you to go with this. Basically, is that?
Yes, sir. It's filed that way.
Okay. Thank you.
Any other members have any questions or comments? Thank you all for coming. Please call the next regulation.
Department of Insurance, 806 KAR 9360. This regulation has both agency and staff suggested amendments.
806 KR 9360 amends to establish a $10,000 registration fee for a person seeking a pharmacy benefit manager license. State the $1,000 annual licensing fee. List mandatory requirements for a license application of a person seeking a pharmacy benefit manager license, and update the pharmacy benefit manager license application form to reflect the most current recent date of the form's amendment, include the registration fee and license fee combined total, and clarify language that all applications shall include a check never to be mailed separately. The staff suggested amendment amends various sections to comply with KRS Chapter 13A and amends Section 2 for consistency with statute, changing references from May 31st to May 30th. The agency amendment amends Section 23B to add that a pharmacy benefit manager that solely provides services for a workers' compensation plan shall not pay the registration fee of $10,000, and updates the pharmacy benefit manager license application for consistency and to comply with KRS Chapter 13A. Additionally, the agency submitted an updated physical impact statement and regulatory impact analysis and tiering statement.
Thank you all for coming today. Would you please identify yourselves for the record?
Russell Coy, counsel, and I'd like to apologize for Commissioner Clark that she's not here today. She's at an NEIC meeting. Otherwise, she'd be here.
Beth Taylor, staff attorney.
Thank you all for coming today. I know a few members have questions. Before we do that, there is a staff amendment. Is there a motion? Is there a second? Without objection, so ordered. There is also an agency amendment. Is there a motion?
Motion.
There we go. Without objection, so ordered. Now, going into questions, I believe my co-chair, Senator West, has a question.
Yes. This is just for my personal information only, and you may not know the answer to this. Off the top of your head, do you happen to know how many PBMs we have in the state of Kentucky that this would apply? Take the workers' comp people out of it. Just overall, how many PBMs do we have in Kentucky?
We currently have 70 registered in Kentucky and licensed. We have 2 we're working on getting licensed in addition to that, and that's total. That does include the workers' comp. We only have 4 that are solely workers' comp. So we have 66 currently licensed.
So this reg would probably only apply to 4, is what you're telling me, probably?
No, the opposite. It would exempt the 4 and would apply the $10,000 fee to the 66.
Okay, I'm sorry. I was looking at one provision where it says workers' compensation plan shall not pay the registration fee. So that would apply to the 4.
They shall not pay the additional registration fee,
Okay.
and the other 66 will pay it.
Yes, that's what I
Okay.
was thinking. Yes.
Okay.
Thank you.
Yes.
Yep.
Thank you.
Do any other members have any questions? Senator Yates.
I just had a question as it relates to the agency amendment, that as it looks like we're including all insurers, employers, government programs, but there's an exclusion just for workers' comp. Why did we carve out just for workers' comp PBMs?
Workers' comp rates are set by the Department of Workers' Claims, and they're by statute. So they don't have the ability to absorb the fee. That was the comment that was provided to us. And upon consideration, they're smaller entities, and most of Senate Bill 188 does not apply to them, which is what this additional fee addresses.
And we believe that the government programs and the insurers can absorb the fee in comparison to the workers' comp insurance?
That's the understanding because of the rates being set by statute for workers' comp.
Okay, and does the cabinet agree with that?
Yes.
Okay.
Do any other members have questions? Thank you all for coming. Give Commissioner Clark our regards. Please call the next regulation.
Public Service Commission 807 KAR 5015, and this regulation has staff suggested amendments.
807-5015 amends requirements for utility pole attachments to expedite expansion of broadband by expediting the application completeness review, allowing attachers with multiple pending applications to prioritize an application, increase from 1,000 to 3,000 the number of poles that may be requested through a single application, streamlining and clarifying invoice and payment processes, increasing from 60 to 90 days the time for an attacher to file an application exceeding 3,000 poles, establishing minimum content requirements for special contracts for applications exceeding 3,000 poles, facilitating the complaint process for a special contract that cannot be negotiated within 15 business days of the start of good faith efforts, and reducing from 180 to 60 days the window for a final order by the Commission. The staff suggested amendment amends various sections to comply with KRS Chapter 13A and amends Section 3 to update tariff dates commensurate with the projected potential effective date of this administrative regulation.
Would you please identify yourself for the record?
Jeb Penny, Executive Advisor to the Public Service Commission.
Thank you for coming today. We do have a speaker in opposition. Before we get into that, I'm going to go ahead and adopt. There's a staff amendment. Is there a motion to adopt the staff amendment? Thank you all. Without objection, it is so ordered. So if you just want to give a brief overview of what this regulation does, then we'll bring the speaker in opposition come up, and then if you want to address their concerns as well.
Okay, thank you. The genesis of this regulation started in 2021 during one of the legislative sessions, which directed the Public Service Commission to promulgate regulations specifically addressing broadband attachments to utility poles. Before then, it had just been done by a tariff or on an ad hoc basis. The Commission complied with that, and in late 2021 or early 2022, the regulation became effective. During the latter part of 2023 and 2024, the Commission became aware that there might be issues with the relationship between attachers and utilities. So the Commission opened up a docket to address those issues. Correspondingly, during the 2024 session, Senate Joint Resolution 175 was enacted, and that had directed the Public Service Commission to, within I think 60 or 75 days of the date of the resolution, to adopt or amend on an emergency basis the existing pole attachment regulations to, I believe that the term was to expedite the deployment of broadband attachments in unserved and underserved areas. It also directed the Commission to open up a docket, which luckily the Commission already had open, to address the concerns for the attachments related to federal and state grants for the like of that. So the Commission in late June of 2024 filed its first emergency amendments to the pole attachment regulation. And then undertook a series of stakeholder meetings with pole attachers and utilities as well, which culminated in the second emergency amendment, which was filed in February at the same time as an amended ordinary amendment in February, trying to get feedback from the utilities on that. And so the ordinary amendment that we're here on today with the ordinary regulation with the amendments is the same as the emergency amendments that the Commission promulgated in February of this year.
Thank you. Do any members have any questions at this time? Okay. If you want to step back from the table, and then we'll let those speaking in opposition come up. I believe it's Audrey Erstenberger, Kentucky Resources Council. Thank you. Come to the table. Please introduce yourself for the record, and the floor is yours.
Thank you, Chairman. I'm Audrey Ernstberger with Kentucky Resources Council. And Chairman Lewis, Chairman West, members of the subcommittee, thank you so much for the opportunity to be here today. I'm here today to ask you, the honorable members of the subcommittee, to help convince the Public Service Commission that the deployment of broadband using PSC-regulated utility poles is best served by including the rights and interests of landowners in the process of facilitating third-party attachments to those poles. As you know, KRC is a nonprofit environmental advocacy organization. We're incorporated under the laws of the Commonwealth of Kentucky and dedicated to providing legal assistance without charge on a wide range of environmental issues. KRC in the past has represented landowners in Kentucky who have been subject to efforts to co-locate cable or other third-party communication cables on telephone poles that were erected and maintained under easements with specific limitations that did not allow third-party use of those easements. KRC's concerns, which were addressed to the Commission but then were rejected, pertain to Section 2 of the Ordinary Regulation, which prescribes the scope of the duty of regulated utilities to provide access to utility poles and facilities. We believe, as proposed under Section 2, subsection 1, this is a mandate. It mandates that the PSC regulated utility shall allow access to any pole, duct, conduit, or right-of-way owned or controlled by it to any cable television system operator, telecommunications carrier, broadband, internet provider, or government unit. There are a few exceptions, but none of those exceptions and nothing in the mandate in Section 2, subsection 1 requires that, 1, the utility have the power to allow such third-party access, or 2, the requesting party has the legal right to use the easement. KRC believes that this section of the regulation should be revised to require the utility to deny access to attachment or third-party use of an easement for broadband unless there's a deed, lease, or easement from the surface owner of the property that authorizes such use by the third party for those proposed purposes. No utility that has been granted or which is condemned an easement for the utility poles and wires has the legal right to allow the use of that easement unless the landowner or the court has then granted that right. And the PSC cannot expand on the utility's rights or force a landowner to accept third-party use of an easement. So in order to fully protect the rights of landowners who have granted the utility easement and whose across property the broadband access to poles is then sought, the utility should deny the access unless there's a demonstration that the requesting party has the right-of-way, an easement, a license, a franchise, or other sort of agreement from the landowner allowing for the construction or maintenance of the attachments or facilities by a third party. KRC has a suite of recommendations for the subcommittee that I'd like to go over just very quickly. The first is a change of language in Section 2 to 1 that instead of the existing language, instead say, require that the utility deny access to any pole, duct, conduit, or right-of-way on a non-discriminatory basis if there is insufficient demonstration that the requesting party possesses a right-of-way easement, license, franchise, or other agreement from the landowner allowing for the construction or maintenance of attachments or facilities by that party. In addition to being what we believe the right thing to do procedurally, KRC believes that to the extent that the PSC is mandating by regulation that a utility grant access in all cases, even when it's maybe perhaps written out of an existing easement, it is in effect taking by physical intrusion by requiring the utility to then allow trespass into that existing easement. So in addition to this change in language in the regulation, there are two other provisions I'd ask you to consider today. The first one would be, they would both be aimed at protecting the rights of the landowners across whose property the broadband provider seeks the pole attachment. So the first would be that at the time an application is made for pole attachment access, the requester should provide the landowner with a certified copy of that application. And then that puts the burden on the landowner who would like to make any objection, who might believe that the easement doesn't allow for that, to then go forward and make that objection to the utility and the PSC regarding the third-party use. The second would be a provision be added where there's a, in the case where there is a bona fide dispute regarding whether the requesting party's documentation demonstrates the right to access the pole attachment, the utility should reject the application until there can be a determination from a court of competent jurisdiction regarding the underlying right of access dispute or an agreement has been reached between those parties. I would like to clarify that KRC fully supports the deployment of broadband in Kentucky and the co-location of facilities, but believes that in no case should the PSC mandate third-party access to easements for purposes of co-location or pole attachment and be proved absent the demonstrations that I've discussed earlier. And the PSC, should not be in the business of mandating takings by physical intrusion by requiring the utilities to accept the use of their poles and rights of way where the utilities lack the legal right to do so. Thank you so much for your consideration.
Thank you for coming. I know we are going to have a few members with questions. If you
Sure.
want to address those, and then we'll let him come back up as well and address the PSC. First will be my co-chair, West.
Thank you, Mr. Chairman. You said a lot there. It sounds like a bar exam question.
I'm so sorry.
You've got licenses and takings and eminent domain and all wrapped up into one.
That's right.
And my questions are basically trying to gain more understanding of what you're trying to say. Okay, you said it very well. I'm just so my first question is doesn't the law itself, if they say a company that owns the pole, doesn't that presuppose that they have a legal right to that pole attachment to start with, and therefore I wouldn't need all the things that you're talking about? Help me with that. I don't know the answer to that.
Often that ownership is fleshed out through other agreements or an easement, for example.
Right.
So KRC would we have represented folks where there might be an easement that allows the pole to be used for certain purposes, but they might specifically exclude broadband. That is actually a legitimate.
Okay, so if that easement excluded broadband, then the entity, would they have ownership technically of that pole, for broadband purposes? So that would presuppose they don't have ownership, right?
KRC would say that they don't have ownership over the pole for broadband purposes.
Right, because according to the contract, the legally binding eminent domain or easement contract there. For second question, when someone has an easement or right to the pole, it's very broad. My people can come in and they can tear up the grass around it, and they can whatever they need to do to attach whatever line we're talking about. By sheer ownership of the easement, doesn't that give them a license or the ability to subcontract or to carry out the will of the PSC to allow these other attachments? And where I'm going with this is like, let's take the utilities, for example. They can allow AT&T to attach. So what makes the broadband company any different than AT&T, that we've done for years? Don't they have an actual license if they do have ownership of the easement?
I see what you're getting at. I do, and thank you for your question and the points that you make. I do think that there's an important distinction that was not in my testimony, which is on a case-by-case basis or an easement-by-easement basis. There are plenty of easements where this won't become an issue because there's broad language. The right for a third-party attacher is reasonably within that language, and there wouldn't be a problem with the landowner or the other folks involved in this kind of scenario. That being said, in the cases that we're discussing, and like the first question, where there's an explicit exclusion, for example, and then the landowners are then excluded from a process, and their land is then subject to the things that you just described, being torn up on a consistent basis, because not only of the installation but that maintenance. That doesn't have to be inherently a problem unless it's not within the language of the binding agreement itself. And so the recommendations that were made were really, I like to, it was long-winded, but really getting at the scope of duty, the notice, and then kind of a ducks in the row requirement to make sure that it's within the language of the easement before work actually begins.
2 quick follow-ups, Mr. Chairman. They'll be very brief. When things get complicated, you kind of have to be long-winded sometimes to get the full effect. So I totally understand that. So 2 scenarios. Is it your opinion that there are many easements out there that exclude broadband? I've never seen those out there, but
I can only speak to KRC's clients.
Gotcha.
We have had several folks come in requesting representation, and
they have agreements.
They have agreements that have
Gotcha.
said this is crossed out.
And so I'm assuming you answered that question. Next question. I'm assuming you're also talking about cases where there is no actual agreement. There's no physical. You're also talking about that as well, where there's the entity cannot produce a physical document.
Right. There's maybe lack of documentation, and then there's concern about how that particular land is being used.
Now, if we have eminent domain, would there be a document?
Well, not necessarily, but there would be a just compensation for a physical taking. So
the only document would be the court records.
Right.
Gotcha. That's my only. Thank you.
Sound like a judiciary committee in here. I don't know. Senator Yates.
Thank you, Mr. Chair, and thank you for being here testifying. When I was president of the Louisville Metro Council, that's when we implemented, I guess in 2016, it was One Touch Make Ready, and we realized then how important the expansion of broadband was to each and everybody that, the kids that didn't have access to internet, it was so far behind the communities that didn't. And then the other problem is we were trying to get broadband expanded. It wasn't fair to the homeowners who did have the easement, because you'd have 4 or 5 different people showing up, touching the poles and moving it. AT&T would have to move their line, and then the different ones. And so we decided to, in order to make it more efficient, expand to more people, and then trying to bring in Google Fiber at the time as well. That's when we started that with One Touch Make Ready. It was challenged in federal court, and then they upheld it. It actually became the model, which I think I'm really proud of, because all parts of the United States have used that same model in a lot of ways. At the same time, in fact, I'm working on a case right now where I think it's an unjustifiable taking. I'm working into it, so you have to protect that homeowner's interest. A lot of times, it's almost an abuse of the homeowner's interest when we don't allow. If we just specifically exclude one, then you have to have different people coming up and moving their lines over and over, so it becomes almost an overuse of that easements, which really affects the people's day-to-day lives. So when we did the hearings on this, the most common response I heard is that they wanted the efficiency to get it done, because they're looking up and they don't know if there's 6 lines right on that pole. They don't know which one's which, or really have a care. And I didn't want to have running through one neighbor saying no, which would stop the other kids down the street from having access to internet. So I kind of get what you're saying, is that you want to make sure that they're otherwise protected, but I know it's what we have to do from a public protection standpoint, is we do that balancing act. And I think in Kentucky it is so important that we get internet access to the community. that it's almost embarrassing to know at today's age that we have parts of Kentucky that don't have that. When we go to the National Conference of State Legislatures, they look at us when we're saying that's still something we're working on, like they're almost puzzled. So I think that has to be a paramount in what we do. If you do have ideas that we can still do that efficiently, that wouldn't otherwise hold things up or slow that down or increase the cost, I'm all ears. But that is one that we spent about a year balancing, and I really fought hard to lead that effort and was really proud of it.
Thank you so much for your comments and points, Senator Yates. You're absolutely right. I mean, Kentucky needs broadband, and nothing in what I'm trying to say is really trying to say anything against that idea, that deployment. I will say, to your point, though, if efficiency is a concern, and then we allow a situation where the PSC is mandating a taking, those issues can end up in court anyway. So we're looking at it from both sides, but I will go back through the recommendations and honor some of the points you made and see if there are any better points I could make in terms of efficiency of the process.
Thank you. Any other members with questions for Ms. Ernstberger? Okay, Mr. Penny, if you would like to come back up and address any of those concerns. Floor is yours.
Thank you, Chair. I'd like to begin by addressing what the Commission can and cannot regulate. The first thing the Commission does is regulate the rates and services of utilities. It does not have jurisdiction over broadband providers, and it doesn't even really have jurisdiction over a property dispute between a utility and a private property owner. That's not where the Commission's jurisdiction lies. And so that underlies part of the Commission's reason for not adopting some of the recommendations that Mr. Fitzgerald filed on behalf of the Kentucky Resources Commission. But also I want to say is that I don't think that the Commission has read its regulation by mandating access where the underlying attacher does not have a legal right to access those poles. Like I said, the Commission does not have jurisdiction over easements or the property rights of the pole owners or the people over whose property it goes. So I'm not as familiar with some of the disputes that might arise from this. But the prevailing law on pole attachments has, and it's the way the Kentucky Commission has interpreted it when it's come to it for, when people have come to it for informal interpretations, is that the attacher only has the same rights as the utility does. So if the utility's easement is a broad easement, like say for example a utility easement, which is very broad language, I think there was a federal district court in southern Indiana said that that type of easement is broad enough to allow a third-party attacher to come through in the form of, I think it was maybe charter. In southern Indiana making that attachment. But in other cases, if that easement is only for that electric company or only for that telephone company, then there wouldn't be a right for that third-party attacher to attach to that. And the regulation should not mandate it, nor the Public Service Commission mandate access to that pole or create a taking. Several of the utilities that have pole attachment tariffs actually have a requirement in their tariff that the attacher have the legal right to attach to the pole. They don't have the affirmative must provide an agreement or must provide the underlying easement to that, but all the utility is doing is processing the application, say you may have access to the pole, but the relationship with the underlying property owner is between the third-party attacher and the underlying property owner. I also do want to point out that Mr. Fitzgerald in his comments to us suggested that a attacher or requester mail by certified mail to every affected property owner a copy of the application. In many cases, there is no application. Just from what I've learned through the administrative process that we've been going through, it's simply a computer system where a third-party attacher will log on. I believe the LG&E and KU call it Catapult with a K, where you log in and you put in the data where you want those poles. There may not be an application to send, but it's also going to be an increased cost to the broadband attachers, which might then imply, I think, the new requirements regarding the fiscal impact statements from the Public Service Commission on that. And for the third part, Mr. Fitzgerald in the comments also suggested that the Public Service Commission get in between the dispute between an underlying property owner as well as the third-party attacher. Well, that is an expansion of the Commission's jurisdiction over two entities that currently it does not have jurisdiction over. A broadband provider are excluded by statute from the Public Service Commission's jurisdiction, and the Commission's jurisdiction expands only to utilities and not to people. So that is why the Commission did not amend its regulation in response to Mr. Fitzgerald's comments, but also the Commission's never read the regulation to mandate access to poles to which the third-party attacher would not have legal right to do so.
Thank you. Do any members have questions? Chairman West.
I'm tracking pretty well with your response. The only question I had that I didn't track was you say there may not be an application.
A written application.
Gotcha. I was going to say that the regulation itself presupposes an application.
Right.
We're talking about increasing it from 1,000 poles to 3,000 poles. You're saying what you're calling an application may be just a computer entry.
To the best of my knowledge, yes.
Okay. Thank you.
Any other members of the questions? Well, very good discussion. It will move on to the Committee of Jurisdiction. Thank you all for coming today. That is our last regulation. However, I would be remiss if I did not recognize we have a guest in the room today, Representative Bridges.
Thank you, Mr. Chair. I have an esteemed guest who happens to be my third grandchild, and his name is Augustus Jack Bridges. We call him Augie, so if you don't mind, give him a warm welcome. Thank you.
Hold committee stand at ease. I will yield to my co-chair.
Thank you, Mr. Chairman. I had to get permission first, but I would just really like to say that I truly appreciate all the hard work of Eric Clark that he has done for me personally and for this committee. I think today is officially his last Administrative Regs Committee meeting. He will be moving on to greener pastures, and I just want to say that the committee appreciates all of his hard work over the years, and unfortunately for him, he may be back up here in the near future on the other side. Maybe, I don't know, but it's been a pleasure to work with you.
Yeah, Eric, thank you so much. We'll see you soon, I'm sure. That is the end of the agenda.
The next Regulations Review Subcommittee will be meeting on September 9th at 1 p.m. That is a Tuesday.
Does anybody have a conflict with this agenda, with that date? Seeing none, meeting is adjourned.